You are listening to the Wealth Formula Podcast with Buck Joffrey. Get ready to change your life.
Welcome, everybody. This is Buck Joffrey with the Wealth Formula Podcast coming to you from Montecito, California. Today, I want to talk to you about, we're going to talk about another perspective on asset protection. We've talked about asset protection several times on this show with various different attorneys on the matter, including my own Doug Lodmell. Now, we have a different perspective today from a different guy, which is always good to get a few different ideas on how that works. You know, before we begin with that, I do want to kind of give you a little bit of background on the sort of personal finance topics around this in general. And specifically, one of the things I've learned over the past couple, I wouldn't say couple, actually, it's been several years now, is that asset protection and estate planning are not one and the same. And that's really important because just because you're doing some kind of advanced planning on one side doesn't mean you got the other one covered. Asset protection is simply protection against creditors. The most extreme and probably best example of that is an offshore trust, often done in the Cook Islands, for example. That's a rock solid way to protect your assets. But you know what? It's not actually an estate planning vehicle, and you don't want to mistake that. Since this week's podcast specifically deals with asset protection, I wanted to take an opportunity here just to give you sort of a little bit of what my understanding of estate planning 101 is here. And again, I'm not an attorney, so check with your own, attorney about these estate planning issues. They are things that I think about a lot, and I've talked to a lot of attorneys. So I'm going to give you my take on that. Okay, so first of all, let's start with the simple matter of estate taxes, which may or may not affect you. As of today, if you're single, you can leave up to $13.61 million to your heirs without being subject to any sort of estate taxes. And if you're married, basically double that. Now, as long as you're below that, the two things that you need at a bare minimum to ensure that you don't make your loved ones miserable when you die are a living trust and a will. Now, the key difference between a will and a living trust lies in how they manage and actually distribute your assets during your lifetime and after your death. Okay, so a will, everybody knows, you've heard the will. Everybody's got to have a will, right? Yeah, we all learned that at some point along in our life. All the will is, it's a legal document that outlines how you want your assets distributed after you pass away, who gets what, that kind of thing, right? Okay, but it only takes effect upon your death, and more importantly, the point I need to make to you is that once you die, if all you have is a will, it has to go through this process known as probate, and that is a court process, okay? And we'll get back to that in a second. But on the other hand, a living trust is a legal arrangement where you transfer ownership of your assets into a trust during your lifetime, okay? You're not giving anything away. The trust is managed by a trustee, which, can actually be can be you for the benefit of your beneficiaries. And upon your death, the assets in the trust are then distributed according to your instructions, and most importantly, bypassing the probate process. Okay, so the living trust is actually not fundamentally all that different. It's basically you, right? Now, I have LLCs, I have things that I own. Instead of, just for a second, just imagine anywhere you put your own name as an owner, you would put, say you're Bob Smith Living Trust is the owner. That's all. It's the same social security number, everything. It's the same. It's just being able to do that and have a document bypasses probate for you in the future. Now, you'll want to avoid probate at all costs if you don't want to make life difficult on your loved ones, okay? Probate is the legal process that takes place after someone dies to distribute their assets and property to the rightful heirs or beneficiaries. Of course, you already have that in the trust, but it has to go through the court system, and that can be time-consuming. It is time-consuming. In some states, it can take up to a year or more. It's very expensive, and it's open to the public. And it can drag on for, like I said, for months, even years, especially if the estate is complex or there's disputes among heirs. So a living trust allows assets to be distributed quickly after death without court involvement, okay? And again, I got to emphasize, probate is terrible. Probate fees, court costs, attorney fees, executor fees, these can eat up a significant portion of a person's estate value. And with a living trust, you avoid most of these costs that really are associated with probate. So if you have not done so, the one thing I will tell you, and the one takeaway that hopefully I can have your family thank me for someday, is that you get these documents done, a will and a living trust. And, it's not expensive. A living trust is not expensive, and your family is going to thank you for it. So, okay, so that was my opportunity to give you a little bit of a estate planning 101. So let's get back to asset protection, and that is a topic of this week's Wealth Formula podcast, which we will have after these messages. Welcome back to the show, everyone. Today, my guest on Wealth Formula podcast is John Scaveland. And John is an experienced and nationally recognized attorney with an extensive experience protecting clients' assets throughout the United States. John, welcome to the program.
Well, thank you. Appreciate it.
And let's start out with this. Let's start out with just a little bit of review, okay? We've talked about some of these things before, but it's always good to kind of, review some of the main concepts that are really important for personal finance, but B, also to get different perspectives. So when you think about asset protection and estate planning, how do you think about them? Maybe it's a good idea to even just define them for people who are kind of new to this, and then how are they related?
No, that's great. So estate planning, I call death planning. It's what most people would think of as wills, power of attorneys, living trust, revocable trust. That's what I call estate planning. Very important, Buck, because in the event you die, we want to avoid probate. And probate is a court case where the county is going to supervise the administration of your estate. Now, asset protection plugs into your estate plan, whatever it is you have. So I often get asked all the time, John, can you do my living trust for me? And I work nationally in all 50 states. The answer is no. I always refer to the client to a local estate planning attorney, and then I'll plug my asset protection plan into their living trust. So what's the difference? Well, asset protection, I like to call net worth insurance, Buck. All I'm worried about is if the client gets sued, how do we avoid taking a loss? And so they're very different animals. One is probate avoidance. A lot of people think their living trust provides asset protection. It does not at all.
Right.
There is none. Whereas asset protection is purely all about how do we protect assets from lawsuits.
So your focus is asset protection, right? So let's talk about, there's different people even in my audience. We have people who are probably, maybe just starting out. Maybe they make six figures now. Then we have others who are worth, tens of millions of dollars. So how do you determine what you need?
Great question, Buck. So that's one of the things I pride myself on is we will help someone who's just starting out investing in their first property or their first syndication, whatever that might be, towards over $100 million. And to your point, Buck, the size of the plan and how we approach it varies basically on the amount of wealth that we have to protect, as well as the assets. And that's what a lot of people don't understand. Just to give you an illustration, a client had a $38 million judgment awarded to her. Sadly, her daughter had died in a hospital. This woman owned no home, no car. She was just destitute. She was broke. It was like winning the lottery for her. So as you can imagine, yes, on the wealth side, we had a lot, 38 million, but we didn't have a large variety of assets. So it is really important whenever you're doing asset protection that it is focused on the assets as well as the size of the estate.
Okay. And do you want to give us more examples of how that, when you say that, what do you mean by that?
Yeah. So let's take some of the common assets clients need to protect. First and foremost are their liquid assets. So that could be publicly traded stock. That could be privately traded stock. As an aside, Buck, it doesn't seem like a week goes by that I don't have a client who's done a great job of building a successful business, and their business is a corporation. And I take
Right.
no pleasure in explaining to them, Buck, that I can sue them and take all their stock in their corporation just like I can their Tesla stock.
Sure.
And so liquid assets, crypto, precious metals, personal property. So things like that. What is personal property? That might be your favorite collection, whether those are guns, ornaments, comic books, you name it. It's very interesting to hear what clients invest in, as well as exotic cars, planes, boats, things like that. So the way we protect those is very different, as you can imagine, whether it's liquid or whether it's tangible, and whether it produces liability or whether it doesn't. And so we'll often separate those, Buck. So
Hmm.
I create something that I call a family vault, LLC. That family vault will have zero liability assets in it. So that's where we put the private stock. It's where we put the brokerage account. Now, I do want to be clear on one thing, Buck. One of the things that I see a big mistake many people make when they do their asset protection is they purposely make themselves completely insolvent. And having litigated for over 10 years of my career, I have seen where plans get blown up, Buck, because the judge rules that they're defrauding their creditors. And the reason why that ruling occurs is they literally have squirreled everything they own away into some protected vehicle. So I do want to be clear.
Uh-huh.
When I say we're going to protect brokerages and other liquid assets, I always advise my clients that we need to keep a minimum amount of living expenses exposed to creditors to remain solvent to avoid that attack. But I'll also create a separate LLC for their boats, their business equipment, for their toys, anything that could produce liability. We'll create an equipment LLC for that. But that's just one category. Of course, Buck, if you'd like, happy to elaborate on how do we protect real estate, how do we protect other assets that the client may have.
Well, since we do have a number of real estate investors, why don't you talk a little bit about real estate? What's your philosophy there?
Yeah, well, the gold standard, Buck, is that we would want to bifurcate risk. Bifurcate is simply contain or separate whenever possible the real estate into separate LLCs. Now, I work with my clients all the time. If you were to ask what is really asset protection, John, it's about reducing risk. And so I work with my client as to what their risk tolerance is. The gold standard being one property per LLC, but I have clients who have multiple properties in a single LLC. And as you know, Buck, there's a big difference between the type of risk inherent in a property. So I want to remind your audience there's something we call inside risk. Inside risk is where the property creates an injury. And so you have a tenant or you have a tenant guest hurt on the property. And as you can imagine, multifamily is the highest risk because you got more people on that property, more doors, right?
Yeah.
And then obviously you climb down from an apartment down to eightplex, fourplex, duplex. And then we have short-term rentals. I would tell your audience, a lot of my clients don't realize that short-term rentals are inherently more risky due to you have new people coming onto that property on average less than 7 days, right?
Yeah.
Versus your long-term or mid-term rental. And then obviously land is the least risky, but even then I tell my clients, we're going to put land all in one LLC. We're going to still take precautions like posting a no trespassing sign, things like that.
Right.
But the gold standard, Buck, is that we will have one property per LLC if the client's appetite calls for it.
At what point do you think it's appropriate for people to start looking at the more exotic trusts?
Great question. So I know Doug Lodmell, who you've had on before. He and I know each other well. I was telling you before we joined this call that we agreed to about 95% of the time on our philosophy. Where we diverge at times, I can be more conservative than he is, or he may be more conservative than I am. Here's a good example of that. So 30,000 foot level, Buck, a good plan is going to bifurcate risk. It's going to have privacy, so it doesn't look very appealing to attack or sue someone. Third, we want layers, and that's what your question is alluding to. The fourth, I want to think about maintenance costs. We really want to make sure that the plan is something that is not overly complicated or too cumbersome or expensive for the client. So I've had clients who come to me with a very complicated plan, and they say, John, is this all necessary? So here's my approach. And this is where, full disclosure, Doug Lodmell, who I respect utmost, would disagree with me. And that is, in my practice, from 0 to about 2 to 3 million, we typically are only utilizing LLCs. Once you cross that threshold of 2 to 3 million buck, usually that's when my clients are ready to implement what's called a limited partnership. Limited partnership is a much stronger vehicle that we can utilize. And then once again, when my clients approach that 5 to 10 million mark, is usually when we move them into a bridge trust. And full disclosure, I refer them to Lodmell and Lodmell for that bridge trust. I do think it's the best product on the market for asset protection. The problem is, and in case you're wondering, well, why those thresholds, John, it's simply the expense. That bridge trust is expensive to create and it's expensive to maintain. And so once again, my clients sometimes aren't able to justify the expense or complication with the cost. And so we work with them.
Although I will say this much is that and I do have a bridge trust, and I actually have an offshore trust as well, believe it or not. So
really?
Wow. I will say that the bridge trust is a far more cost-effective vehicle than an offshore trust. And I think for, certainly at that 5 million plus point, I think it's a very reasonable option. And I think Doug generally agrees with that. I mean, most of the people who are going into the bridge trusts are at least people who are headed to that 5 million mark. And so he's anticipating that ahead of time. Let's talk a little bit about, is there any asset protection strategies that you have that may help with tax mitigation?
Yes. So let's talk about taxes real quick. So there's two kinds. There's income tax, and then there's the estate tax. And the estate tax is something that comes into play when someone dies. The current amount in 2024 is 13.61 million, and it is scheduled to drop back on January 1st, 2026. I'm estimating around 6.5, 7 million. It's 5 million adjusted for inflation. So to your point, my asset protection plans will often include a gift trust as a component to it. And there's two reasons for that, Buck. One is I believe a multi-member LLC is much, much stronger than a single member LLC. And so for that partner, I like to create a gift trust because it's separate from husband and wife, and it's a gift trust for the kids usually. My clients are not the trustees, meaning they're not in charge of the trust. They have to name brother, sister, mom, or dad. And usually it's their kids or loved ones who are beneficiaries of that gift trust. So it accomplishes the multi-member LLC aspect. Second, it is something called a step transaction doctrine with the IRS. They don't like gift trusts created the same year you do very large gifts. And so we season a gift trust at the outset of the asset protection plan so that when my clients need to do some estate tax planning, we already have a gift trust stock that we can do some gifting, which allows us to do some discounting, and is a very leveraged tool that we're able to parlay down the road. So to answer your question, we're always going to take care of the estate tax. Now, What about the income tax, John? This is where I get on my soapbox, and forgive me, Buck. Every good asset protection attorney should be working with my client's CPA or tax advisor. They have to go hand in hand. Too many times I see kind of a turf battle, Buck, where the CPA kind of has his turf and the asset protection attorney has their turf, and the two shall never meet in the middle. I'm completely the opposite. I believe the asset protection plan needs to implement the client's tax strategy. And I work with CPAs across the country, and my referrals, I'd say over 80% of my referrals are all from CPAs. Why? Because they need me to create my asset protection plan in order for them to save their clients' tax dollars. And so they go hand in hand when properly done.
Right. Well, let's talk a little bit about some of the new laws that are coming up, some of the things that we can expect. You mentioned one of them, which is, sort of the sunsetting of the estate tax limitations. You want to talk a little bit? You want to just emphasize some of those changes?
Yep. And here's again where I feel like I'm a radical.
Yeah.
A lot of your estate planning attorneys will say, "Hey, we need to do some planning right now, today. Let's do it." My approach is a little bit different, Buck. First of all, the sunset provision is really a nuance of the Trump tax bill that was in
Yeah.
2020, and it is scheduled to again end on January 1st, 2026. But my approach is that let's see how this 2024 election occurs in November. Let's see what the makeup of the White House and Congress is going to look like. And just so you're aware, Buck, the estate tax has never dropped. I'll say that again. The federal estate tax amount, the exemption amount, has never dropped in the history of the United States. So I tend to be more of an optimist. I believe that when political cover is no longer needed and the election has occurred, I think there's a great chance where the Democrats and the Republicans will join together in extending the currently very high federal estate tax of 13.61 million. And just so you know, that is being adjusted every year. So
I guess what my question would be,
Yeah.
what's the point of, I mean, if you can get grandfathered in, why would you wait and play chicken with a potential decrease in those limits?
Great question. First, we have all 2025 to do any planning. So back in 2012, President Obama had threatened to reduce the federal estate tax then. And myself and I worked at a very large law firm. My entire department, we worked up until December 31st of 2011 doing a lot of planning. But it never happened.
Yep.
And come 2012, I had a lot of clients with remorse saying, well, I just gifted large amounts of wealth. I want
Oh.
that back. So my approach is back. I think it's premature to do planning. We still have 2025 that any gifts that occur that year can be grandfathered under the current regime. I don't see the point in
So
it right now.
you bring an interesting point up too, because you said I want that back. I'm not sure I understand why people would want that back if they have planned their estate trust in such a way that they have not lost control.
And that's the point. Back then, a lot of estate planning attorneys are not looking at it from an asset protection standpoint. And so a lot of those last minute gifts, we didn't have the time to put in an asset protection structure, Buck.
Mm-hmm.
But your point is well taken. Whenever I'm doing gifting with clients, that gifting should be an ownership interest of an LLC or limited partnership so that the client always retains control. And depending on the tax strategy, typically can divert all the income to themselves. What we're gifting is an ownership interest only so that the client continues to retain control. But Buck, when you are forced to get appraisals, you're forced to do last minute planning, that is not a luxury a lot of clients
Right.
have back.
And I guess that would be an argument for planning ahead.
Yes, all the more.
Right,
Exactly.
right. Instead of waiting. So other laws, let's see, anything else in the estate planning space or gifting or anything like that we ought to be aware of?
No, that's the big one that's coming down the pike, but I assume you've heard of the beneficial owner information.
Yeah. A lot of people have been talking about that. Maybe give us a little bit of an update on, what that's all about, what all the noise is all about, and how it changes things.
Well, the latest update on that is it's being challenged. So
Well, what is it? Let's start with that.
First of all, this was a law that was passed in 2021, went into effect of January 1st of this year, that requires an overwhelming majority of LLCs, limited partnerships, any formation, any entity that requires you to file something with your state to form it. So the big exclusion there, Buck, and I was kind of surprised, is trusts. Now, they are talking about including trusts in an update, so let's not get too excited. But right now, as it stands, if you own an LLC, limited partnership, or corporation, or any kind of business entity, odds are you're going to have to file a beneficial owner information report. There are some exemptions and exclusions. I'll tell you the biggest one is if the business has 20 or more employees and grosses more than 5 million in revenue, they are exempt. So that isn't going to cover a lot of people, but there's some other minor exemptions. But what is the beneficial owner information report? If you are making decisions, you're usually the manager, executive, CEO, something like general partner, you are going to have to be reported. Or if you own more than 25%. So I tell your listeners, catch that percentage. I don't have to include anyone who owns 25% or less. They don't have to be included. Well, what's included? Well, basically, this beneficial ownership information report needs to disclose basic information. And what is the law intended to prevent, Buck? It was all about fighting terrorism and money laundering. So it's reported to FinCEN, which is a department of the U.S. Treasury, and who is able to access it? It's any government authority, so FBI, Attorney General, local law enforcement, that if they have a reason to believe that you're involved in money laundering or terrorism, they would have access to your BOI report.
So there's a lot of concern about that in terms of privacy issues. What's your take on that?
Yeah, thank you for asking that question, Beck. Too many people are out there prognosticating that the privacy states that we like to utilize, Wyoming, Nevada, Delaware,
Right.
And several others, are worthless now.
Yep.
And that's simply not true.
Mm-hmm.
The reason why it's not true is, remember, what is the privacy we're trying to accomplish, Buck? It is the attorney who's excited to sue Buck. And when we do an asset search for Buck on any real estate, on any businesses, do we get a hit? Well, the plaintiff attorney has no access to that BOI report. It's a confidential document, very similar to your taxes. I can't access your taxes because you filed those with the IRS. Similarly, I can't access this BOI report that you filed with FinCEN.
Right. So I was trying to find this. Somebody asked me a question about this, which I didn't really know the answer to, which was something about actually registering with FinCEN.
Yeah, you can register with FinCEN and get what's called a FinCEN ID.
Yeah, what's the point of that? And is there any advantage, disadvantage?
Yeah, the point is this. So often my clients will have numerous LLCs. We'll have a holding company. That holding company will then own other subsidiary LLCs underneath. What we do, Buck, is we get a FinCEN ID for the holding company. And then that way, when we file the BOI reports for all the underlying LLCs and entities, we just simply, it's just easier to file the BOI report reporting the FinCEN ID of the parent company. But individuals can get a FinCEN ID. Usually that's overkill because, in my opinion, we should be reporting the holding company, which owns everything below.
Okay, got it. So that's where the FinCEN ID comes in. Is there a cost saving if you do that or anything like it? No.
Yeah, not at all. It's kind of like, I want you to think of it as obtaining your own Social Security number so that when you go to report, you now use the Social Security number. It's similar to that. It's all it is just tying you to a number. So it makes filing subsequent BOI reports easy.
Is beneficial ownership information, all of this stuff, coming under any sort of constitutional challenges or anything like that?
Yes, exactly. That's what I was alluding to earlier. So we've had some court cases that have come through, and as some are successfully, it's going up on appeal. I suspect this may very well end up in front of the Supreme Court. So it's very possible this may be greatly modified or undone. However, I get this question a lot. Well, do I still need to file my BOI report? The problem is, until the final court has ruled, either ruling it unconstitutional or upholding it, it's still the law of the land. And
Right.
So we still are under obligation to file that BOI report.
Got it. Well, John, tell us a little bit about your practice and, who your typical clients are and that kind of thing.
Great. Our practice is solely on asset protection. So in my background, I used to own one of the largest law firms as an equity partner there. There, I always did asset protection, estate planning, litigation, real estate, business law. But Buck, I had a COVID scare a couple years ago. I just turned 50. And at that time, I realized life was getting too short to do something I don't enjoy doing anymore.
Yeah.
And my passion has always been about asset protection. So that's all we do here at Scabelin PLLC. And so our clientele really focuses on 5 individuals. There's the real estate investor. Who is that? If you own more than your home, you're a real estate investor. We focus on business owners. So no matter how you've created it, you'd be amazed how many have not structured their business properly. Then we work with high net worth individuals. Usually they have large brokerage accounts or crypto or something they need to protect. And then the last 2 are what I call high target occupations, Buck. That's going to be your doctors, your lawyers, your dentists, your professional athletes, your celebrities. And then the last one is kind of like that story I told you earlier. I call them windfall recipients. Whether they're a lottery winner, they just inherited a boatload of money, or they've won a successful plaintiff judgment. My clients fall in all those realms. And again, they start as small as their first property to well over $100 million.
The website is scabelin.com. That's SKABELUND.com. John, thank you so much for being on Wealth Formula Podcast.
Well, thank you, Buck. And I'll just share that ultimateassetprotection.com is my sister website. A lot easier to spell than Scabelin.com.
That's a good idea. Good idea. Thanks again.
Thank you.
Be right back. Welcome back to the show, everyone. Hope you enjoyed it. Remember, asset protection is not the same as estate planning. Make sure you get both taken care of, whether you use our guest today or, somebody like Doug. For asset protection, that's important, but estate planning is also very important. As far as attorneys for estate planning, usually you want to have somebody in your own state. So in the situations like that, for example, if I use Doug, Doug actually sent me somebody who's been on our show, Joe Longo, for California specifically. So anyway, important stuff to get taken care of. It's not sexy, but it's stuff that has to be done. That's it for me this week on Wealth Formula Podcast. This is Buck Joffrey signing off.
Thank you for listening to the Wealth Formula Podcast. Visit us on the web at wealthformula.com. The information contained in this podcast are opinions, not fact. As always, consult your own financial team before making any investment. See you next time.